Ladies and gentlemen, welcome to Friday, May the 8th. It is 9:35 a.m. It is technically the 5th hour AP Gov class session, but if you're tuning in, watching from a different class, welcome, 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 as we take on our final lecture series that leads us to the test. That doesn't mean we're done. That doesn't mean our time together at 9 a.m. on Friday mornings is over. But this is our final piece of the lecture series for what brings us into the AP test on Monday, May 11th. And that is a tamed down, one lecture only, Unit 3 discussion, conversation, and this Unit 3 discussion, conversation, and lecture, ladies and gentlemen, is about civil rights and civil liberties. Without further ado, I'm going to share my screen. Please post any questions that pop up into the chat function. Otherwise, write them down and I'll stay on the call after your colleagues leave and after I stop the recording process so that you can ask those questions in a more intimate setting. Here we go, here we go, here we go, y'all. Now, if you're wondering, Mr. Book, how come your theme this week looks like the cover of an Ed Sheeran album? My answer is I really like Ed Sheeran, and sometimes I'm listening to Ed Sheeran when I'm making your slides, and I must have been doing that when I did this. Unit 3, circle, underline, highlight, civil rights and civil liberties. Let's go. I'm actually going to stay right here. All right, so civil rights, like I said earlier, you guys, and civil liberties. Civil rights deal with group rights, all right? How we are treated as members of certain groups in this country. What do I mean by that? How we are treated as women, how we are treated as African Americans, how we are treated as members of the LGBTQ community, how we are treated based on our age, how we are treated based on our religion. These are all conversations that if we feel like we are not treated equally as the quote-unquote majority, then there needs to be a conversation of a fight for civil rights, all right? So civil rights are based on group rights. And if we're talking about group rights, we're talking about the protection of groups by the government. Again, the protection of groups by the government, all right? And how the government is going to protect us in light of how our employers are treating us, in light of how private businesses are treating us. Or if it's the federal government that we're looking for some civil rights protections, it's federal government protect us for how the states and local governments are treating these groups based on the fact that we are a group of women, we are African Americans, we are members of the LGBTQ community, we are young students under the age of 18, we are young people under the age of 21, we are a member of a religious community that has been treated in a discriminatory way. Ladies and gentlemen, we're going to talk about the passage of the 14th Amendment and how the 14th Amendment on Monday's test is considered the cheat amendment, and how the 14th Amendment impacts groups through the lens of civil rights, but also how the 14th Amendment impacts individuals through civil liberties. So, civil liberties, individual rights, what does that mean? Well, civil liberties, ladies and gentlemen, is all about protections against the abuses of the government. Again, protections against the abuses of the government on an individualistic basis. Is individualistic a word? I don't know. I may have just made that up. All right. So on an individual basis, ladies and gentlemen, civil liberties are all about protections against the abuses of government on an individual basis, all right? On an individual basis. So that means that you are being treated poorly. Your civil liberties, meaning your freedoms and liberties, are being taken away by the government, and there needs to be some protections against the fact that the government is taking those civil liberties, those personal freedoms away. And civil liberties deals with the fact that the government needs to step up and change the way that they are acting, because the way that they are acting, the actions that are being taken, are removing your personal civil liberties. All right? So that's a whole lot of talk about rights and freedoms. What rights are in the original Constitution, ladies and gentlemen? Let's start there. Well, in the OGC, the original gangster Constitution, before the Constitution was ratified, so this is the Constitution that was argued about, debated on the Constitutional Convention floor. Ladies and gentlemen, this Constitution did not include the Bill of Rights, right? Because the Bill of Rights is not ratified until after the original Constitution is proposed, and the Bill of Rights is not added into the original Constitution until the Anti-Federalists say, listen, our states, the states in which the Anti-Federalists represented at the Constitutional Convention, our states are not going to ratify this law of the land until the Bill of Rights is added in, all right? Because we need some more protections. We need more rights than what is listed on this page right here. All right, so we've talked about a lot of these things from the original Constitution already. We talked about some of them just last week. The writ of habeas corpus. Look at how much Latin you guys are going to be learning right here. The writ of habeas corpus, which means if you're being arrested or if you're being charged for a crime, there needs to be an explanation for why, all right? And we've talked about how during times of crisis throughout history, the writ of habeas corpus has been done away with, all right? How President Abraham Lincoln suspended habeas corpus during the Civil War and was potentially arresting people or holding people in contempt without giving them any explanation of why. The term bill of attainder and the fact that there can be no bills of attainder is in the original Constitution, ladies and gentlemen. That means that you cannot sentence to a punishment without a trial. There must be a fair trial if somebody is going to be sentenced to a punishment for a crime that they may or may not have committed. And then there's ex post facto laws, all right? You cannot charge somebody with a crime after a law is made. Again, you cannot charge somebody with a crime after a law is made, all right? So if Brendan Davis stole that car, that is his background right now, if Brendan Davis stole that car, we can't pass a law that says if that car that you stole has those wing doors that go up as opposed to the doors that go out, then you are actually going to be charged to a life sentence for just stealing a car. All right, so Brendan steals a car. He gets charged for stealing that car. But after he is arrested for stealing that car, a new law is created so that the book is laid down on him so that Brendan rots in jail. And that new law says if you steal a car that has wing-tip doors, that means that you are going to serve a life sentence. That would be an ex post facto law, almost as if we're trying to charge Brendan with more of a crime just for the fact that we don't like Brendan, or maybe we don't like the groups that Brendan is a part of from a civil rights standpoint, the groups that he would be a part of based on his sexuality, religion, race, whatever it might be, gender, etc. All right? And then in the original Constitution, it says there needs to be a trial by jury in federal courts. A trial by jury in federal courts. All right? That's not enough. So those original kind of judicial-backed terms that are in the original Constitution, you guys, that's not enough. The Anti-Federalists, they wanted a Bill of Rights. Remember, the Anti-Federalists are all about this. Brutus I, as a original document, as a required original document, ladies and gentlemen, Brutus I is all about, listen, check this out. We need protections from a strong federal government, all right? And the original Constitution and everything that the Federalist Papers are saying, those lousy Federalists, Alexander Hamilton, John Jay, James Madison, et cetera, et cetera, et cetera, those lousy Federalists, they're not thinking of tyranny of the majority, of one strong federal government, one strong unitary government, and the impact that one strong federal government can have in squashing state rights, local rights, and individual freedoms. Remember, Brutus I is all about, we just broke free from a tyranny of the majority structure, and this current Constitution is going to provide so many more opportunities for tyranny of the majority to exist based on the fact that the federal government is huge and strong and state governments are much weaker. So Brutus I says the Constitution gives too much power to the central government and not enough power to the states and to individuals, all right? So the Anti-Federalists say, listen, this thing is not going to get ratified, this original Constitution. There needs to be a Bill of Rights that's going to provide protections to individuals, protections that are needed, protections from the federal government. Now, the Federalists, they didn't want a Bill of Rights. Why? They felt like the Bill of Rights would limit the rights of individuals. You're going to put all these rights into a box, right? As opposed to letting individual states say what is important in terms of the protections of individual rights. Because guess what? With 13 original colonies, ladies and gentlemen, it's not like you can jump in your car that can max out at 140 miles per hour, but you're going to drive the 75 mile per hour speed limit on the highway and cross state borders in a matter of hours, or jump in an airplane and cross state borders to get to those 13 original colonies in a matter of an hour or two. You're taking a horse and buggy, you're taking a journey that is going to be dangerous, and it's going to take you days, weeks, months in order to cross state lines, all right? With that in mind, states are so individualistic, and states know their individual needs. So the Federalists are like, let the states have individual Bill of Rights in their state constitutions, because states know their citizens, and the citizens of states are so unique compared to all citizens within the entirety of these United States of America. The Federalists said, let's have a Bill of Rights in individual states, not a federal U.S. Bill of Rights. But the anti-federalists, they win out. You don't hear me say those words too often in this class, right? Anti-federalists win out. Because, listen, when you have bullies like Alexander Hamilton, Mr. Book, Alexander Hamilton's not a bully, he's my hero. Well, listen, Alexander Hamilton's kind of a bully, all right? He stays up all night, every night. He works nonstop in order to try to teach himself everything that he can know about law, teach himself everything he can know about precedent that has been set from previous government structures all across the modernized Western world. And he studies the philosophers, the John Locke's, the Montesquieu's, the Jean-Jacques Rousseau's of the world. And he is so well versed in history that he bullies his way into making strong arguments. So Federalists, ladies and gentlemen, they oftentimes win out on these conversations during the foundation of our country. But when it comes to the Bill of Rights, it's the anti-federalists that win out. The Bill of Rights is added in 1751, and this secures the ratification of the Constitution for those states that were sort of on edge until a federal Bill of Rights was added in to the Constitution. All right. So what does the Bill of Rights do? Well, the Bill of Rights, in the grand scheme of civil rights versus civil liberties, the Bill of Rights outlines the civil liberties. It outlines the civil liberties, the guaranteed freedoms for individuals, and the protections from government action. The guaranteed freedoms for individuals and the protections for government action. That's essentially the definition of what a civil liberty is. All right. Now, the fight for equality, this term equality, has existed within our country since the very first time that we declared our independence from Great Britain. Remember the Declaration of Independence, ladies and gentlemen, written by Thomas Jefferson. The Declaration of Independence is really a plea for help as the states, the 13 original colonies, as the states say, we are going to try to free ourselves from Great Britain, from the tyranny that exists under the British Crown. And we are pleading for help from our allies, from other countries that also think that Great Britain is full of crap, that Great Britain is just tyrannical, and that Great Britain has no right to take over and rule across a gigantic pond, nations that should have freedom and jurisdiction in and of their own. All right. So in this Declaration of Independence, in this plea for help, ladies and gentlemen, we see the words, all men are created equal. The term equality is brought up. But what does equality truly mean? Well, first of all, the term equality is mentioned this many times in the original Constitution. This many times, 0 times. Equality is mentioned 0 times in the original Constitution. Ladies and gentlemen, the term equality is mentioned this many times in the Bill of Rights. It is not until the 1860s that we see the term equality pop up into the Constitution. And guess what amendment was ratified in the 1860s? You guessed it, your cheat amendment, the 14th Amendment. It's not until the 14th Amendment, your cheat amendment, that the term equality is even mentioned in the Constitution, and that is in the 1860s, nearly 70 years or 7 decades after the Constitution was ratified. So when Jefferson says all men are created equal, and when the 14th Amendment is ratified in the 1860s, what does equality mean? And what does equality not mean? Here's what it does not mean. Equality, as it's been set forth throughout American history, and still today, it does not mean that we're all the same, that we're all alike, that we all fit in one perfect box. It does not mean that there are no differences amongst people. It does not mean that we are all entitled to perfect equal rights or equal rewards based on the opportunities that we are given. Mr. Book, this is a rather bleak slide here. Please move on and tell me what equality does mean, because I don't like this slide. Or maybe you do. Maybe you like the individualistic nature of equality. Maybe you like the individualistic nature of the way in which equality has been structured within our country. And here's what I mean by that. Equality means that everybody has unalienable rights. The right to life that needs to be protected from a federal, state, and local government perspective. The right to liberties and freedoms that need to be protected. And the rights to property, or as Jefferson describes it, the rights to the pursuit of happiness in terms of pursuing property, not just property that you live on, but property that you drive in, property that you sip out of, property that goes into what you sip out of in terms of the products that you would like to buy and the property that you would like to own. All right. Ladies and gentlemen, equality in this country does mean that we all have equality of opportunity. We have the same chance to succeed, or we're supposed to have the same chance to succeed. But it doesn't mean that after we are rewarded with these opportunities, it does not mean that we are all going to have equal outcomes based on these equal opportunities. You all have the chance to go to Harvard. You all have the equal opportunity to apply to Harvard, but you're not going to have the equal results or the equal rewards of getting into Harvard. In fact, when it comes down to the percentages of people who get into Harvard, 0 of you are going to get into Harvard statistically. All right? 0 of you. However, I have taught a total of 6 students that have gotten into Harvard, and so many people from Stony Creek High School have gotten into Harvard, and other equally wonderful schools that are wonderful for you guys as individuals, not as a collective group. All right. So we have the equality of opportunity, same chance to succeed, or relative same chance to succeed in this country, ladies and gentlemen. We do not have equality of results or equal rewards. All right. The Cheat Amendment, how does this fit in? Well, if we're going to talk about civil rights, the clause within the 14th Amendment that we're going to focus on is the Equal Protection Clause. And if we're going to focus on civil liberties, the clause within the 14th Amendment is called the Due Process Clause. Circle, underline, highlight, please, the 14th Amendment. For civil rights, we're focused in on the Equal Protection Clause within the 14th Amendment. And if we're going to talk about civil liberties, we're going to focus in on the Due Process Clause within the 14th Amendment, the very first place in the Constitution that the word equality appears some 7 decades after the original Constitution and the Bill of Rights is ratified. Here's what the 14th Amendment says. Here's your cheat amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property. Check it out. There is your equality of opportunity, all right? Everyone shall be given the equality of opportunity to have the privileges and immunities of all citizens of the United States. There's your equality of opportunity. All right, all citizens of the United States should have equal opportunities, equal privileges, equal immunities. Now, ladies and gentlemen, I know that that hasn't always been the case for all Americans. So don't think that I'm looking through some glasses that are just whitewashed as a white male, all right, of some privilege, all right? Do not think that I'm just looking through that lens as I look through these glasses today, all right? Don't think that I'm some nearsighted AP Gov teacher that's just painting one picture of the world. I'm not, and I never will, and I never have. When I say that equality of opportunity or the same chance to succeed, when I say that that is supposed to exist, I say that in the vocabulary of the 14th Amendment, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. I know that that was largely ignored for 100 years and still has been largely ignored still today for some groups of people and some individuals here in 2020. What I'm trying to say to you is that this 14th Amendment, written in the 1860s, ratified in the 1860s, it hasn't been given a backbone. It hasn't been given a spine. It hasn't been protected. It hasn't been enforced throughout U.S. history. It's existed. It's been in our Constitution since the 1860s. But the federal government has not enforced this part of the 14th Amendment throughout history. States can make Jim Crow laws. Do Jim Crow laws give every citizen of states equal opportunities to privilege and immunities that everybody else in states that didn't have Jim Crow laws had? No. Ladies and gentlemen, did voting restrictions, all right, did taking away people's right to vote based on poll taxes, based on taking tests in order to be allowed to vote, did these take away people's equality of opportunity when it comes to voting? Yes. But remember, it's not until the federal government enforces laws like the 14th Amendment that we can see an equality of opportunity pop up. All right? Now, the 14th Amendment, when it comes to civil rights, that's where the Equal Protection Clause pops in. Take a look at the last little bit of this 14th Amendment statement here. Nor deny to any person within its jurisdiction the equal protection of the laws. That means that the Equal Protection Clause means that all citizens must be treated equally in the court of law. Equal protection of the laws. All people must be treated equally in places of public accommodation. All people must be treated equally in schools. All people must be treated equally as groups within the workplace. That's the 14th Amendment perspective when it comes to civil rights. When it comes to civil liberties, the 14th Amendment clause is the due process clause here in red, all right? Nor shall any state deprive any person of life, liberty, or property without the due process of law, all right? So there must be formal steps taken to charge somebody for a crime, all right? There must be formal steps taken, ladies and gentlemen. If your life, liberty, or property are taken away from you, you must be given the right to the judicial process, the right to due process, a fair trial, habeas corpus. You must be given a right to have your voice heard if any of your liberties are taken away. And that's the civil liberties portion of the 14th Amendment. Here are those two things laid out for you on a slide as I take a sip of my coffee. All right. Are there any questions at this point, you guys? That I do a All right, where we last left off here was our long discussion about our Cheat Amendment, the 14th Amendment here, and how how civil rights and civil liberties work into the two clauses here, the Due Process Clause and the Equal Protection Clause of the 14th Amendment. All right, so ladies and gentlemen, civil rights and civil liberties. We've talked a lot about them. We've gone over a lot of these things, but let's take a look at a couple of other pieces. Civil liberties, we talked about individuals, we talked about protections from the government. What the government cannot do, Congress shall make no law abridging people's civil rights and their civil liberties, no law abridging or taking away our personal freedoms. All right. Civil liberties apply to individuals. They apply to individuals through the lens of our freedom of speech, our freedom of the press, our freedom to assemble, religion, petition the government, trial by jury, etc., etc., etc. This would be helpful. Sorry about that. All right. Protections within the Constitution provides against the abuses of government powers, for example, like censoring your speech, censoring the press, restricting your right to assemble, restricting your right to have freedom of religion. Remember, ladies and gentlemen, within civil liberties and within civil liberties in regards to religion, there are two clauses, the Establishment Clause and the Free Exercise Clause. The government shall make no law that is going to establish any religion, all right? And then the government shall make no law that is going to prevent you from freely exercising your religious rights. Now, Mr. Book, I'm not allowed to go to my synagogue. I'm not allowed to go to my church right now. I'm not allowed to go to my mosque right now. I'm not allowed to go to temple right now, Mr. Book. So are you telling me that based on these stay-at-home orders and based on any other legislation that's been passed by either the local, state, or federal government, that right now during the COVID-19 crisis that we're dealing with currently, that I could have a civil liberties lawsuit on my hands, that I could sue the government because I am having my free exercise, the right to show up and worship, I'm having those rights restricted? And here's what I'm going to say to you. Ladies and gentlemen, we're about to open up, and we already have seen a whole lot of lawsuits and judicial processes based on civil rights and civil liberties of what is going on currently with the COVID-19 crisis. It is going to we're going to see a tremendous number of cases climb the appellate ladder. We're going to have to see the Supreme Court make some rulings based on what civil liberties are going to be taken away and what civil liberties are going to be constitutionally taken away if it means keeping the most people safe. And as we know, during times of crisis, legislative power tends to shrink, legislative power tends to grow, executive power tends to grow, and civil liberties tend to diminish, shrink, or go away. Civil rights, protections by the government, protecting the minority from majority abuse, protection from discrimination. Ladies and gentlemen, civil rights, what the government should do in order to provide a backbone to legislation like the 14th Amendment. But what oftentimes the government doesn't do when it comes to states getting away with ignoring the 14th Amendment, ignoring the 13th Amendment, ignoring the 15th Amendment, ignoring parts of the Bill of Rights. Civil rights deal with what the government should do in order to give a backbone to legislation that is supposed to provide equal opportunities to groups, not just individuals. All right. So this slide is wonderful, ladies and gentlemen, and it has a tremendous wealth of information here. As you write down these things in your spiral notebook, I'll let you guys catch up for one quick second here. A much tamed version of this, you guys, is found on page 10 on the most recent Print This for the AP Test document. Page 10 has the brief, so you can find it in a quick and easy place. This is going to be fresh in your mind on Monday, so you're going to be able to talk about it. But if you want to reference something that I said, the very tamed down version of this is found on the top of page 10 on the Print This document for the AP Test. All right. So our examples of civil liberties: the freedom of speech, the right to privacy, the right to be free from unreasonable searches of your home, ladies and gentlemen, the right to a fair court trial, the right to bear arms. These are all a part of the freedoms and individual liberties when it comes to civil liberties that we are supposed to be given. But remember, and I can't emphasize this enough, none of these freedoms are absolute. What does that mean, Mr. Book? None of these freedoms are absolute. None of these freedoms are absolute means that none of these freedoms are going to be automatically protected by state and local governments. All right? None of these freedoms are going to be protected from local police forces in all instances. People with authority are going to ignore largely some of these things, and it's up to the federal government to enforce them, to make them absolute. But even then, none of these civil liberties are going to be 100% absolute. Throughout history, the Supreme Court has ruled that these rights may be limited in the interest of the greater public good. So my friends, even if the legislative branch or the executive branch of the federal government enforces some of these civil liberties or enforces these civil rights or enforces the legislation that or the executive orders that are supposed to give a backbone to these civil liberties and civil rights, the Supreme Court may still make rulings that limit in order to provide for the greater public good. As we saw in the Supreme Court case Korematsu versus the United States, that said that the internment of Japanese Americans is indeed constitutional during a time of war in order to keep the most people safe, since we didn't know who were spies. We didn't know who was dangerous from the Japanese American community during this time. And it wasn't until generations later that Japanese Americans were indeed given some sort of reparations for these deeds by the federal government. All right. But remember, during this time when Executive Order 9066 was passed by FDR, the Supreme Court upheld the constitutionality of this action, of this executive order. And maybe that was because, remember from last week, FDR had packed the courts with 6 different justices to the Supreme Court. All right, 6 different justices to the Supreme Court during his 4 terms in office. So it was a rather FDR-friendly crowd in the Supreme Court. So it might make sense that Korematsu versus United States, that decision did say that Executive Order 9066 was indeed constitutional. So SCHS has ruled that these rights may be limited in the interest of the greater public good. One of your best examples from history is Korematsu versus US. One of your greatest examples of history is Executive Order 9066. Ladies and gentlemen, how does this all fit to the AP test? What could be asked on the AP test? Well, on Monday, ladies and gentlemen, you absolutely could have a question that deals with the individual rights, civil liberties, civil rights, times throughout history where you feel like your civil liberties or civil rights have been removed, restricted, and times throughout history where you think that the federal or state governments have done a good job or a bad job in protecting those individual rights. And think how much content you guys would have to use as evidence if that was your question. All right. I can't with good conscience leave the conversation about civil rights and civil liberties if I don't bring up this very important, but also if we were in the classroom, I think that this would be confusing to you. More confusing than we are as I talk to you via this silly screen that I had to get glasses for because I was getting so many headaches by the time I got to my Friday lessons. Ladies and gentlemen, selective incorporation is a term that if we were doing this in person, it would have been confusing, but let's keep it simple to one slide with a couple of notes on the side here. All right? Circle, underline, highlight, please, selective incorporation. Did you know that before 1925, folks, state and local governments were not held accountable by the federal government to uphold the Federal Bill of Rights? What? Before 1925, the Bill of Rights applied to the federal government in protecting our civil liberties, our personal liberties. But prior to 1925, states could largely ignore the Federal Bill of Rights. How is that possible, Mr. Book? Well, remember, in the tug of war between states and the federal government that we call federalism, the goal has been for states to still have some power. Remember, Amendment 10 says that all rights, all things that do not fall within the original Constitution, all things that are not written down or enumerated in the Constitution, they fall to the states. They're reserved for the states. So it is the federal government and the court's interpretation of the 10th Amendment that says that, hey, states should be allowed to be laboratories of democracy, all right? And therefore, the Bill of Rights, all 10 amendments, should only have jurisdiction within the federal perspective. 1925 changes that, ladies and gentlemen, and it is the Supreme Court case of Gitlow versus New York and the Supreme Court case in 1833 of Barron v. Baltimore. Barron v. Baltimore, Barron v. the city of Baltimore in 1833, and the 1925 case, as you see here, of Gitlow versus New York, that starts to bring up this conversation known as selective incorporation. Since 1925, the court has applied the Bill of Rights to state laws on a case-by-case basis, all right? Meaning that the First Amendment is going to be selectively incorporated, meaning that the federal government can indeed protect individuals on a state and local basis through the lens of the First Amendment, through the lens of the Second Amendment. But let's get to the Third Amendment. The Third Amendment has never been selectively incorporated. Therefore, the following rights have not been incorporated and may still be restricted by state and local governments. So the federal government has not swooped in, have not flown in with a Superman red, white, and blue cape on, wearing a red, white, and blue leotard. All right? The federal government has not swooped in and tried to protect the Third Amendment rights to individuals, the Fifth Amendment right, the Seventh Amendment, or the Eighth Amendment rights of the individuals. So these are the amendments that have still, ladies and gentlemen, not been selectively incorporated. But Amendments 1, Mr. Buck, what's the First Amendment? Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or of abridging the freedom of speech, or of the press, or of the right of the people to peacefully assemble and to petition the government. Remember the First Amendment, you guys? I had you guys remember it as RAPS. All right, RAPS. Religion, assembly, petition. Religion, assembly, petition. Press and speech. RAPS, R-A-P-P-S. Religion, assembly, petition, press, and speech. All right, so the First Amendment has been selectively incorporated throughout history since 1925. The Second Amendment has been selectively incorporated. The Second Amendment says that we have the right to keep and bear arms. The Third Amendment has never been selectively incorporated, and that is the protection against forced quartering of our troops. The Fourth Amendment has been selectively incorporated. That is that we must have protection against unreasonable searches and seizures. The Fourth Amendment The Fifth Amendment has not been selectively incorporated, and the Fifth Amendment there is that we have the right to indictment by a grand jury, by a grand jury. If we feel like we have been deprived our rights to life, liberty, or property, we have the right to indictment by a grand jury. Ladies and gentlemen, the Sixth Amendment, we have the right to a speedy and public trial. We have the right to a speedy and public trial that has been selectively incorporated. The Seventh Amendment, the right to a jury trial in civil cases, has not been selectively incorporated. The right to the Eighth Amendment protections against excessive bail and or fines, that has not been selectively incorporated. The Ninth Amendment, ladies and gentlemen, the enumeration in the Constitution of certain rights shall not be denied or and should not be denied by the people, and the people should have rights. The Ninth Amendment has been selectively incorporated. And the 10th Amendment, ladies and gentlemen, that any laws not enumerated or written down in the Constitution as falling to the federal government shall be reserved to states, that has been selectively incorporated. All of these have been selectively incorporated since relatively recently, 1925, and the Gitlow versus New York SCHS case, which ruled that state limits on speech and press could not exceed the limits allowed by the federal government. All right? Ladies and gentlemen, from a review standpoint, just like all of my lectures have had over the last couple weeks, from a review standpoint, these 3 videos not only are great review from what I just talked about, but they also relate the history that I spoke of, the terms that I spoke of today, and they relate it to some current COVID-19 coronavirus quarantine style of examples. All right. These are so fresh and so clean, to quote one of my favorite hip hop groups, Outkast. These are so relevant to right now. And all 3 links are under 10 minutes. What? They're under 10 minutes if you get a chance to go back and take a look at some of this review, because it is somewhat dense. All right. Ladies and gentlemen, I'm going to share a different screen with you to wrap things up today. All right. I'm going to share a whiteboard screen with you. For question 1 on Monday, for the argumentative essay, for evidence piece number 2, where you can use anything from this class in order to provide evidence that supports your thesis, ladies and gentlemen, let's talk about some SCHS cases. Civil rights versus civil liberties. All right, are you following what I'm talking about here? SCHS cases that fit into the current topic at hand, civil rights versus civil liberties. All right, here is where we get into the wow factor on the AP exam. All right, evidence number 2 is where we get into that wow factor. All right, where you're not just going to take the second foundational document that was provided for you already in the prompt, but you're going to pull something else out. All right, ladies and gentlemen, remember on the AP test, the spare tire rule is very much still in effect. If you have the time to add a spare tire, you absolutely should do that. And that means that if you are required for argumentative essay question number 1 to provide 2 pieces of evidence and you still have time, your spare tire is to give a 3rd piece of evidence that backs your argument in case the grader thinks your first piece of evidence or your second piece of evidence is weak somehow, which they're not going to do. All right, so absolutely, a spare tire is on the table when it comes to question 1. If you have the time to provide a 3rd piece of evidence, do it. The wow factor on the AP exam on Monday is going to come in question 1. All right? So the first case I want to talk to you about is Schenck versus the United States. Schenck versus the United States. SCHS upheld that during a time of war, in this case, World War I, that the federal government can punish or restrict free speech. All right. In this case, ladies and gentlemen, the freedom of speech that was denied here in Schenck versus U.S. was a person who was speaking out about war, a person that was speaking out about World War I, and was passing out legislation about how World War I, how we shouldn't be involved in World War I, and listen, the federal government punished this person for speaking out against the war. All right, and this climbed the appellate ladder. You know, wait a minute, I thought I had free speech. I thought I could say whatever I want. I thought I could speak out against this war. Well, SCHS upholds that during the time of war, the federal government can indeed restrict free speech. All right, and it's from Schenck versus the United States that we get the world famous majority opinion laid out that sets up the free exercise clause. I think I just misspelled exercise, my bad, but we don't have time to fix that. The free exercise clause, all right? And in this majority opinion, the free exercise clause pops up here. Sorry. I don't want to talk free exercise clause. Sorry, it's early. The clear and present danger clause is what I wanted to talk about. The clear and present danger clause, which says essentially you cannot yell fire in a crowded theater. All right? Because that puts the public in clear and present danger. All right? So the government can punish you if you are having speech that puts people in clear or present danger. All right, you speak out about a war. Well, that could, or you are going to be, if you speak out about a war, or if you are going to be doing things that might be considered espionage, that could put our troops in danger. All right, ladies and gentlemen, that could put people in clear and present danger. The clear and present danger clause, you cannot yell fire in a crowded theater. This is where our freedom of speech can be restricted during times of crisis. A great example for this first FRQ, if we're getting into times when civil liberties can be restricted, freedom of speech being one of them. All right. Now, what about in school, you guys? Do students leave their rights at the door when they enter into school? You know about Tinker v. Des Moines. And in Tinker v. Des Moines, we know that symbolic speech is protected, but not all speech is protected in a public school. All right. Symbolic speech was protected by the Supreme Court in Tinker v. Des Moines when Mary Beth Tinker wore that black armband to protest the Vietnam War. Ladies and gentlemen, was suspended for that. And the Supreme Court said that she could indeed wear the armband. Symbolic speech is protected because symbolic speech is not going to hinder the normal day-to-day interactions of a school day for administration or for teachers. However, here's a case where Morse v. Frederick, ladies and gentlemen, is a case where speech is very much limited in public schools. This is the bong hits for Jesus case. All right. Joseph Frederick, you guys, makes a sign that says bong hits for Jesus. And he brings that sign to a school event on school property. All right. The principal is Principal Morse. Principal Morse suspends Joe Frederick for 10 days for organizing and bringing a sign on a school property to a school function. All right. Joe Frederick was trying to get himself in trouble so that he could have a reason to sue the school and sue his principal. And so Joe Frederick sues the school, you guys, citing that his First Amendment freedom of speech was being restricted. In the lower district courts, they ruled in favor of Morse. The principal, all right, and it is appealed in the Court of Appeals they rule in favor of Frederick. So then SCHS takes it on, and in a 5-4 decision, they side with Morse, the principal. All right. Now, ladies and gentlemen, in the majority opinion, all right, the majority opinion says the right to speech does not extend to promoting drug usage. The right to speech does not extend to the promoting drug usage. Restrictions on speech in school, therefore, is constitutional in some instances. And guess what? One of my favorite concurring opinions, all right, because it just shows how cut and dry some of our Supreme Court justices can be. The concurring opinion, and if you remember back from last week, this means that this was written by a justice who voted along with the majority, but for different reasons. The majority opinion said, and this was written by, some of you guys know your current Supreme Court justices pretty well. This was written by Supreme Court Justice Clarence Earl Thomas, and Clarence Thomas said this, and you guys probably would disagree with this statement. Thomas said this: students have no right to free speech in public schools, and Tinker versus Des Moines should be thrown out. And that just shows the grumpiness that can come out in the majority concurring or dissenting opinions. Ladies and gentlemen, there's a tremendous number of Supreme Court cases on my mug that I could bring up here that go along with this civil rights versus civil liberties discussion, that go along with protections of those civil liberties or civil rights, or they go along with the restrictions of civil liberties or civil rights. But you guys have a ton of information there. There's more cases involved in this document here that you're going to use on the AP test. And in those 3 review videos that are up on the Google Slides that I'm about to release to you that I already showed you, they have a tremendous amount of more and different Supreme Court cases that bring up freedom of religion in times when freedom of religion has been restricted, all right? When rights from a perspective of skin color or gender or sexuality have either been protected through the lens of the Supreme Court or restricted through the lens of the Supreme Court, all right? Ladies and gentlemen, thank you so much for being a great audience. That is my lecture today. And with that, that closes our remote lecture